Hi everyone, welcome to the employment space. This channel is here to provide to you a 360-degree view of the employment relationship. In today's post, I'm going to provide the 9 most important federal employment laws that I believe all U.S. employers should know and understand. And whether you're a small business or an executive or human resources professional, employment lawyer, whether in-house or outside counsel, these laws that I'm going to list for you today are important to know and understand. And here's the truth about these laws. Violation of these laws typically don't stem from intentional misconduct, but rather misunderstanding or not knowing if they actually apply to your business. So in this video today, in this post, I'm going to list for you these 9 important federal employment laws, and following this post, I'll be sure to dissect each one of them a little further for you, okay? So let's get into it. Okay, everyone, let's get started with number 1, the Fair Labor Standards Act, also known as FLSA. This is a good place to start because this is a law that seemingly employers violate the most. This law governs minimum wage, overtime, employee classification, record keeping, and child labor laws, and also even how tipped employees are treated. The biggest mistake employers make here is assuming that paying someone a salary or giving them a fancy title means they're exempt from overtime, and that's not how the law works. Exempt status is about job duties first, not titles, not agreements, and not what the employee prefers. Now don't worry, we started here with this what I consider to be a very important law, and they're all important. But in episode 3, we're going to start with dissecting the Fair Labor Standards Act with information that employers should know about. We'll do that even more in the next post, okay? Number 2, Title VII of the Civil Rights Act. Title VII prohibits discrimination, harassment, and retaliation based on race, color, religion, sex, and national origin. This includes pregnancy, sexual orientation, and gender identity. One important thing employers miss, you may ask, is the retaliation claims. Now, retaliation claims often succeed even when the discrimination claim doesn't. How you respond to complaints as an employer matters just as much as the complaint itself. Now, I know you may be shocked with that information, but when we do a separate post, which will be the post following the one regarding the FLSA, we'll dive in deeper and I'll explain how sometimes discrimination claims under Title VII fail and the retaliation claims can be successful. Let's move on to number 3. Americans with Disabilities Act, also known as the ADEA. The ADEA requires employers to provide a reasonable accommodation or even leave of absence to qualified employees with disabilities. Now, the disability can be either one that is considered mental or physical. What trips employers up isn't usually denying the request for accommodation, but rather it's the failure to engage in the mandatory interactive process. This law is as much about communication and documentation as it is about accommodations. Number 4, Family and Medical Leave Act, also known as FMLA. The FMLA provides eligible employees with job-protected, unpaid leave for certain medical and family reasons. Employers often violate the FMLA not by denying leave, but by interfering with it or retaliating afterward. Timing, documentation, and consistency are critical here. Number 5, the Age Discrimination in Employment Act, also known as the ADEA. The ADEA protects employees age 40 and over from discrimination. Age claims frequently arise during layoffs, reorganizations, or performance management, especially when comments about energy, culture fit, or succession planning enter the conversation. Number 6, the Equal Pay Act, also known as EPA. The Equal Pay Act requires equal pay for equal work, regardless of sex. Intent doesn't matter here, results do. If there's a pay disparity, the employer must be able to justify it with legitimate, documented factors like seniority or merit. Number 7, the National Labor Relations Act, also known as the NLRA. The NLRA protects employees' rights to engage in concerted activity, whether or not your workplace is unionized. This law applies to most private employers, and it often affects workplace policies or confidentiality, social media, and employee complaints. Number 8, the Immigration Reform and Control Act, also known as the IRCA. The IRCA requires employers to verify employment eligibility through the I-9 process. Employers can face liability both for hiring unauthorized workers and for over-documenting or discriminating during verification. Compliance must be precise and neutral. And last, number 9, is the Occupational Safety and Health Act, also known as OSHA. OSHA governs workplace safety and health. Today, enforcement goes beyond physical hazards and increasingly includes heat exposure, workplace violence, and retaliation for safety complaints. Okay, everyone, there you go. These are the 9 laws that form the backbone to federal employment compliance. Again, I can't highlight even more that most risk for employers doesn't come from intentional misconduct, but rather it comes from outdated policies, untrained managers, and the assumptions or some assumptions in the workplace that should no longer be upheld. If you're an employer, the best protection that I would say you should have is to make sure that your policies are updated, your documentation is in compliance. You also have a good relationship that's long going with an experienced employment attorney, and that you are proactive when it comes to compliance, right? Very good. So again, I just want to thank you for stopping by. If you appreciate this information, please like, share, subscribe, and comment. Episode 3 will be me dissecting a bit more, only the information that I think is important for the employment relationship about the Fair Labor Standards Act. Again, this channel is here to provide to you a 360-degree view of the employment relationship. I look forward to seeing you again. Thanks for stopping by. Take care.